In her recent interview, Amber Heard had a lot to say about the jury and her rights and as an American. Unfortunately, her comments are being scrutinized brutally by the internet, and now legal experts have stepped in as well. First Amendment attorney Floyd Abrams thinks Amber Heard needs some lessons in law. He has responded to her directly. So what did the established lawyer have to say? What do people think of the interview? Keep watching to find out. First Amendment lawyer Floyd Abrams responded to Amber Heard's comments about defamation law during an interview with Savannah Guthrie. Heard, who lost a defamation lawsuit against her ex-husband Johnny Depp, made a legally incorrect claim about free speech while speaking with Guthrie, a lawyer licensed to practice in Washington, D.C. During the latest episode of his podcast, Speaking Freely, Abrams pushed back on Heard's claim, suggesting she take a lesson or two in law. Here's what went down in the interview that Abrams is referring to. First, Guthrie said, "Here's the deal with the First Amendment. The First Amendment guarantees free expression. It does not protect defamatory lies, which was the issue in this case." Heard replied, "That's right, you can't go into free speech does not protect you if you go into a crowded theater and yell fire. The Greeks gave us the concept of free speech. That, in my opinion, entails more than just the freedom to speak. It is a liberation to speak truth to power." Guthrie says the word is truth. Heard says, yes. Guthrie says, that was the problem. Heard replied, "That's all I said, and I said it to power. I paid the price." Abrams first cited the 1964 case, New York Times versus Sullivan, in which the Alabama Supreme Court determined that the First Amendment to the United States Constitution does not protect libelous publications. "If I had to guess," Abrams said, "I don't think the court is going to reverse that 1964 case. I don't believe the votes are there to do it, but there is every reason to believe that there are at least 3 votes to do it because 3 members of the court have already indicated that they are willing to do so. My view is that we should hope and do what we can in terms of public opinion and thinking about things like this," Abrams continued. "In terms of communicating with one another, it's just a matter of public opinion being important, which it is." He went on to say that the court is made up of people who are naturally interested in what other people think, and that in this case about freedom itself. So that's where we're at. As for Amber Heard, she should take a law class or two, Abrams said. "I believe she is mistaken about this. As Law and Crime has repeatedly pointed out, the oft-repeated phrase, 'you can't yell fire in a crowded theater,' is not legally correct." According to the First Amendment, Congress shall make no law respecting the establishment of religion or prohibiting its free exercise, limiting the freedom of speech or the press, or limiting the right of the people to assemble peacefully and petition the government for a redress of grievances. Since then, the First Amendment has been interpreted to limit a broader range of government functions than just Congress. Though government restrictions on speech have historically been viewed with suspicion, the First Amendment is not absolute. The government can regulate certain types of speech, such as incitement to imminent lawless action, defamation, obscenity, child pornography, fraud, speech that violates intellectual property laws, fighting words, and certain threats. Naturally, what the government can and cannot regulate is the subject of litigation, and the fire in a crowded theater trope arose from a First Amendment case. Justice Oliver Wendell Holmes Jr. wrote the analogy in Schneck v. U.S. This 1919 Supreme Court case held that an individual could not use the First Amendment to avoid prosecution under the Espionage Act for leafletting against mandatory military conscription during wartime. According to Holmes, such speech posed a clear and present danger of bringing about the substantive evils that Congress has a right to prevent. The most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic, says the original anti-free speech quote, emphasis ours. The analogy is thought to be a reference to the Christmas Eve 1913 Italian hall disaster in Calumet, Michigan. To begin, most people who misinterpret the original line, such as Amber Heard, leave out of the falsely and causing a panic parts of Holmes' quote. These qualifiers are critical to comprehending the situation. Nobody would object to someone yelling fire in a theater that was actually on fire, and a solemn and orderly exit followed. Even Holmes admitted that First Amendment cases involve a question of proximity and degree, and that the Calumet Hall disaster was an extreme example of bad speech. The general public were fully in support of Abrams. One person wrote, "Speaking truth to power entails not caring if the man is legendary or not. You must check his fingers for scissors." On that, another commented, "All of this is excellent, and with all due respect to your extensive knowledge, it is pointless to have experts if the victims are unprotected in practice." The comments went on, and further people stated that the majority of her testimony was incorrect, and others stated, "Truth to power and power to the people, LMAFO. Anyone who has gone to law school will laugh at this." Do you agree with Floyd Abrams? Let us know in the comments down below. Make sure to like and subscribe for more.